report also.
Yes.
My lord, kindly see the FIR once, my lord. Your lordship will find a member of a particular political party, he has lodged the complaint against the petitioner and two others. My lord, the allegation is this, my lord, a conversation made viral to the net. He claims it's a doctored video, my lord, conversation. The tape which has been, my lord, tampered.
The petitioner claims.
Yes, the petitioner, the complainant claims.
Oh, the complainant claims
Yes.
that it is doctored.
Doctored.
All
But
right.
it was the conversation between the sitting member of parliament and one of his, not the party associates.
All right.
Now, Milord, the allegation of the complainant is this, Milord, the conversation is doctored. What the investigation should do, Milord, before lodging a complaint, to compare, to take the voice sample of the original, Milord, the member of parliament whose voice has been doctored, and the tape. These should be sent to the FSL first. Then they should, Milord, they come to the investigation and, Milord, issue the notices in accordance with law. On the straight away, Milord, they have lodged the complaint. Your lordship will find they have not verified anything. And till today, Milord, kindly ask them whether they have taken the voice sample of the member of parliament as per the allegation whose voice has been tampered.
Is the complaint annexed?
Which one, Milord?
The complaint where there is allegation of tampering.
Yes, Milord, the written complaint is here. Milord, kindly, Milord, I am reading it in open court. আমি নিম্ন স্বাক্ষরকারী দিলীপ মাঝি থানা সোয়ানসো আমি সোয়ানসো পার্টির ঘাটাল ব্লকের সভাপতি হইছি আমার অভিযোগ যে নির্বাচনের প্রাক্কালে গত 17/5/2024 তারিখে বেলা আনুমানিক 7টা নাগাদ আমি আমার ফোনে সেই জনপ্রিয় প্রতিনিধি সোয়ানসো এর স্পর্শকাতর অডিও শুনতে পাই উক্ত সম্প্রচারিত অডিও আমাদের প্রিয় প্রতিনিধির কথোপকথনের বিষয়ে জানতে পারায় আমাদের সংগঠন অনুরোধ অবগত হয় যে নিম্নলিখিত ব্যক্তিগণ নির্বাচনের প্রাক্কালে নির্বাচন বিধি উপেক্ষা করে 1 ও 2 নম্বর ব্যক্তি ও 3 নম্বর ব্যক্তি চক্রান্ত করে আমাদের প্রিয় প্রতিনিধির ভয়েস এডিট করে 1 ও 3 নম্বর ব্যক্তির ব্যক্তিগত রাজনৈতিক কুতার্থ চরিত্র করার জন্য প্রিয় প্রতিনিধি বর্তমান সোয়ানসোর ভাবমূর্তি অবগত করার জন্য তৃণমূল কংগ্রেস ঘাটাল ব্লকের পরিকাঠামো সোয়ানসো ব্যক্তির সাথে ব্যক্তি ষড়যন্ত্র করে একটি ফেক অডিও তৈরি করে এবং ফলস পার্সনিফিকেশন করে আমার উক্ত জনপ্রতিনিধিকে বদনাম করার কুপ্রস্তাব হয়েছে so my lord what they should do my lord as soon as the complaint is received they should take away the entire audio clip now they should take away the voice sample of the original person whose voice has been tampered supposedly and then my lord they should done the investigation and register an FIR here my lord as per the my lord that same day my lord kindly see the when the FIR was registered as soon as the my lord the complaint was made the FIR has been registered. This is number one. Second, your lordship will find the sections which has been given by them. My lord, if your lordship can take this chart, my lord, I have make a chart for your lordship. The sections which are involved here.
Yes.
Sir, 1, 417, 419, 420, 468, 469, 552, 120B, 34, 66D, and 67. And your lordship will find, Lord, we have given the details of the offences in one hand, and your lordship we have given the punishment also. Your lordship will find maximum punishment is 7 years. And your lordship knows, Lord, the Honorable Supreme Court's recent decision says, Lord, where the offences are below 7 years, and if the accused is ready to cooperate with the investigation, they should not be taken into custody. This is the recent view. Earlier it was Anish Kumar. Now in a recent judgment in Satyanarayana Kumar, until I shall produce that also. Lord, there it says that if they cooperated, Lord, no action can be taken against them. This is the settled law now. Now, my lord, second, my lord, I told your lordship, my lord, the audio, the authenticity of the audio video, whether it is a genuine or not, my lord, they have not done the FSL till date. So my request before your lordship is this: till that, my lord, the FSL comes before your lordship and they found it is a doctored video, my lord, the protection should be given to them. And my lord, subsequently, if they file an affidavit, my lord, we can give the my lord the counter also.
Well, I think my alignment has finished, my lord. So far, my lord, for the time being, my lord, is whatever is prayer and my lord, what he suggests the court. Now, my lord, this is not a case. My first submission is that he prays for, my lord, the court monitor investigation.
No.
Yes, in fact that I say, I think, my lord, my expression may not be correct.
All right.
But what I intend to say is this: he says that until and unless that ISL report is come, it may come But the thing is this, my lord, it is for their, my lord, instance that the investigation has been stalled. My lord, immediately after the, my lord, the lodging of FIR, they came before this honorable court. They said that day after tomorrow or within a very few days, the election will be held, and one, out of three accused person, one was the, my lord, the candidate, other was his personal assistant, and other was, my lord, the party member who also used to assist the candidate. So all three came up before your lordship by filing two separate deed petition, jointly in one and separately other by another. Now, my lord, prima facie on that very day, just on the day of closing the court for summer vacation, my lord thought that yes, very good, that when there is an election process started, and the candidate who, my lord, one of the accused person, he was the candidate for parliamentary election, so there should not be any such disturbance, whatever be the FIR. So my lord has not gone into that matter and simply said that for the time being, let there be an interim order to this extent. Even, my lord, it has been recorded that my submission was that no coercive steps may be taken for that specific purpose, but investigation be allowed to be carried on. But, my lord, it has been recorded therein that yes, I prayed for that, but my lord was kind enough to stall the investigation also. Now, today on the returnable day, my lord's order was that I have to file a report first. Now, my lord, the report is with me. Now, my lord, kindly have a look, my lord, because there is, my lord, only thing in the report is that, my lord, the FIR annexed, whatever the document says, at least till that date, till the day the investigation was, my lord, suspended for the time being pursuant to my lord's order. Now the question is, my lord, that what the police has to do, that complaint lodged. Now, my lord knows that there are several judgments. I do not want to, my lord, tell before your lordship. By this time, my lord knows very that if it appears from the complaint itself that there is a cognizable offense, even, no doubt.
No.
Now, my lord, even if it is, my lord, it appears that the whatever the offense, if it is, my lord, leveled against that person, then the maximum punishment would be 7 years. But FIR cannot be lost unless and until that, my lord, that there are 5 or 4, my lord, that is, my lord, the parameters, where after in some inquiry, that Lolita Kumari judgment, my lord knows that, possibly paragraph 13 or paragraph 14, that if there is delay in lodging complaint, or, my lord, the family dispute, or in that such matters, first inquiry be done, then FIR be lodged, despite being the fact that it appears from the complaint that there is a, my lord, the cognizable offense, it appears. Otherwise, Lolita Kumari said itself that yes, FIR should be lodged. And there are other honest Kumar also, there are honest Kumar, there are several judgments. Now, my lord, kindly see one thing, that my lord, my learned friends knows, my lord, much more, my lord, and much well than me, that, my lord, there is a, my lord, Niharika judgment. And I think by this time, my lord also gone through Niharika judgment. And Niharika judgment relied upon, my lord, subsequently in other 2 matters by the Honorable Supreme Court. That under what circumstances, my lord, the Article 226, as well as, my lord, the other matters, my lord, the even Article 32. But the court can, my lord, go into that exchange that to stall the proceedings, and also, my lord, interim order not to pass any coercive action. But this is not such matter that, my lord, carve out from that exception as an exception in that Niharika matter. This is not such a matter that the Supreme Court, my lord, in Niharika matter said, very good, this is an exception. It does not come within that, my lord, the exception carved out therein. If you lordship, my lord, kindly, my lord, go through only this particular paragraph, paragraph 33. How an accused person can say that what should be the procedure of the investigation? He can go through, my lord, he can obtain a bail in a regular manner. But why Article 226? Let's say kindly consider one thing in a regular manner. Article 226. Well, Article 226 cannot be invoked in a regular manner. If he says that yes, there is some procedure with regard to investigation before being arrested, then very good. He can approach before the criminal court. If there is a very good defense, then he can go there. But Article 226, why in a regular manner? And that is, my lord, the Supreme Court said it should not be. If your lordship allow me, my lord, I can take only 5 minutes to read out 3 or 4 sub-paragraphs, and I can hand it over to your lordship.
Yes, read out.
May I read out that, my lord?
Yes.
My lord, it is, my lord, reported in 2021, 19 SCC, my lord, page 401. That Niharika judgment. Now, my lord, paragraph 13, may I just read out, my lord, 5 or 4 sub-paragraphs. My lord, paragraph 33.1. Police has the statutory right and duty under the relevant provisions of the Code of Criminal Procedure contained in Chapter 14 of the Code to investigate into a cognizable offence. Courts would not thwart any investigation into the cognizable offences. It is only in case where no cognizable offence or offence of any kind is disclosed in the first information report that the court will not permit an investigation to go on. The power of quashing should be exercised sparingly with circumspection, as it has been observed in the rarest of rare cases, not to be confused with the formation in the context of death penalty and not. While examining an FIR complaint, quashing of which is sought, court cannot embark upon an inquiry as to the reliability or genuineness or otherwise of the allegations. Criminal proceedings ought not to be scuttled at the initial stage, what actually they want to do, or their prayer at least. Quashing of a complaint, FIR, should be an exception rather than an ordinary rule. Ordinarily, the courts are barred from usurping the jurisdiction of the police, since the two organs of the state operate in two specific spheres of activities and one not to trade over the other sphere. The functions of the judiciary and the police are complementary, not overlapping. Save in exceptional cases where non-interference would result in miscarriage of justice. My lord, kindly consider one thing. On the very first day, when my lord was kind enough to take the matter, interfere with the matter, pass an order. Suppose, my lord, on that day itself, their situation was there, that after 2 or 3 days, the election would be held. And all of them are, whatever be their status in that election process, they were involved therein. Now the election is over. That part is over. Now they cannot claim that chapter. Lordship, kindly consider one thing. So far this line is concerned that save in exceptional cases where non-interference could result in miscarriage of justice, the court and the judicial process should not interfere at the stage of investigation of offences. Then extraordinary and inherent powers of the court do not confer an arbitrary jurisdiction. Then first information report is not, and I am not on then. But in this way, and also says, paragraph 33.18, that whenever an interim order is passed by the High Court of no coercive steps to be adopted within the aforesaid parameters, the High Court must clarify what does it mean by no coercive steps. Now, my lord, kindly consider this paragraph only for the time being.
Right now, you want to proceed with the investigation.
Yes.
So you can proceed with the investigation. There
Yes.
is no difficulty. He is not standing in the way of investigation.
No, he says that the process with regard to the next step to be, my lord, carried out, that should be based on this and that. My humble submission, there should not be any such condition right now. The investigator, the IO, they should be free with regard to the investigation, what should be the right thing, what should be the right steps to be taken, my lord, for the purpose of investigation on the basis of that particular FIR.
Very good. Very good.
Lordship, kindly, my lord, have a look just.
Yes.
At the same judgment, your lordship also see 33.14. I'm reading in open court. However, at the same time, the court,
Paragraph
if it
33
thinks
and
fit,
34.
regard to had made the parameter of quash and
And Supreme
self-restraint
Court, my lord,
imposed on law,
after this, my
more
lord,
particularly parameters in PP Kapoor and Bhajan law
several
to
times, my lord,
quash the
relied upon
proceedings. So
this.
court has the 33.14, your lordship also looked into. The same judgment. Whether court has the power or not.
No, but then you are not praying for quashing the FIR over here.
Which where? In this case, my ultimate prayer is quashment of the proceeding.
Is this your
Yes,
prayer?
Milord, the Bhajan Lal's principle, Milord, and recently judgment in Milord the Haji Iqbal's case, Milord, I prayed for quashment of the entire procedure.
Then my Lord Arnab Goswami, after considering Bhajan Lal, Arnab Goswami also says
that is in
that
my favor.
The rarest of the rare. No,
is
they
in
are
my-
the Supreme Court, my Lord. They are the says that yes, there were several the 7 FIR and said 1 FIR.
What is the judgment that you are relying upon, the recent Supreme Court
Yes,
judgment
Haji
regarding
Iqbal, Milord, this one, Milord, kindly see.
taking into custody?
Yes, yes.
Which portion?
A copy আছে
Haji Iqbal, Milord, kindly see.
এই copy আছে reported আরে reported
Where, Milord, the
2020
Your Lordship has referred one of your Lordship's judgment, one para of this, Milord, which I have quoted earlier. Your Lordship has quoted earlier. In 482 and 226, the court, Milord, owes a larger duty to see the complaint. Milord, para 14. Paragraph number 14. Milord, kindly see.
এটা দিস না citation
Para 14. Milord, I'm reading it. At this stage, we would like to observe something important. Even an accused comes before the court invoking either inherent power 42 of the Code of Procedure or extraordinary jurisdiction under section 226 of the Constitution to get the FIR or the criminal proceeding quashed, essentially on the ground such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, which in circumstances court owes you a duty to look into the FIR care and little more closely. We say so because once the complainant decide to proceed against the accused with an ulterior motive for wreaking personal vengeance, then he would ensure that the FIR complaint is very well drafted and all necessary pleadings. The complainant will ensure the averments made in the FIR are such that disclose the necessary ingredients to constitute the offense. Therefore, it will not be just enough to look for the court to look into the averments in the FIR and the complainant alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceeding, the courts owes a duty to look into the many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read between the lines. The court, while exercising its jurisdiction under section 482 or 226 of the Constitution, need not restrict itself only to a stage of the case, but is empowered to take account the overall circumstances leading to the initiation of registration of the proceeding. So my first point before your Lordship is a politically motivated FIR.
1 minute. Just now you referred to some other judgment where there is a direction not to arrest or something.
Yes. Milord, this is the one. Satyanarayana until 2021. SCC Milord 401. Oh, 2022. No, it আমার দাগ দেওয়া আছে. Milord, kindly skip few pages and kindly, Milord, come to the where the Supreme Court has categorized.
Citation
2022, volume 10, Supreme Court 51. Milord, kindly see, Milord, the judgment part. Skip few pages.
Page number is there.
Milord, page number, page 30. 30.
30, yes.
1
Milord, see, Milord, first just keep the Milord 31 where the Supreme Court has categorized the offenses. Milord, kindly see it once. A, the offenses punishable with imprisonment 7 years or less than felling category B and D, which in our case, Milord, all are below 7 years. Other one is death, imprisonment for life. Milord, we are not on that. Second are offenses under NDPS, PMLA, we are not on that. Requisite, Milord, kindly see category A now. What is category A? Ordinarily, summons at the first instance, including permitting an appearance to the lawyer. Milord, got it? B, if such accused does not appear despite service of the summons, the bailable warrant and physical appearance may be issued. 3, non-bailable on the failure to appear despite issuance of bailable warrant. D, non-bailable warrant may be recalled and converted into bailable warrant summon without instituting physical appearance of the accused if such application is moved on the behalf of the accused. E, bail condition of such accused on appearance may be decided without the accused being taken into physical custody or by granting interim bail till the bail application is decided, my lord. Here now, my lord, Supreme Court has crystallized the entire, my lord, the scheme of the act, saying that below 7 years, if the accused is ready to cooperate.
Bail application, I think. So she kindly consider one thing. This is different.
This is the, my lord, the. একবার আমাকে বলতে দিন, বলে তারপর আপনি বলুন।
Did you file any application for bail?
Not yet, my lord, because I have prayed for quashing here before your lordship. The quashment, your lordship, why you file for quashing? Your lordship knows better than me. When the liberty of a person involved, it is the duty of the court to see, my lord, the liberty of the persons cannot be curtailed. That is the reason, my lord, we have filed 226 application, and where there is a vexatious proceeding, politically motivated FIR. And that is the reason Supreme Court says these kind of cases, the court owes a duty to look into the FIR more closely. Not only the averments, but read in between the lines. That is the Supreme Court's judgment. And this is the ratio which says, my lord, generally below 7 years offenses, if the accused ready to undertake, my lord, he should not be taken into custody.
No, but then E has not yet arisen because bail application is yet to be filed.
No, bail application, right. We have not filed it. But our main prayer is quashment of the proceeding.
I get it. So as of now, has summons been issued?
Nothing. But they have not issued 41A also. Arnish Kumar, your lordship knows, below 7 years offenses, 41 needs to be issued.
Has to be issued.
Till today, no 41A. This is number one. And my lord, recently our High Court, my lord, why, my lord, if your lordships feel like that 41 should be issued.
Please come.
Another thing, lordship, kindly consider one thing. Now my learned friend says that 41A has not yet been issued. Now when the FIR lost and when they did
come, possibly you could not issue because of the order passed by the court.
Yes.
Very well.
We could not do anything. We could not do anything.
Court has
our hands are tied.
Well, just one request, my lord.
By the Ghatal police station, by the officer in charge, Ghatal police station, signed on 9th of June 2024. Stop. The investigation of the Ghatal PS case number 174/24, dated 18th of May 2024, could not proceed further in terms of the order passed by this court.
And prior to that, my lord, search or seizure list, whatever obtained, lordship, annexed.
Of May 2024.
We have annexed the seizure list prior to that.
Paragraph.
Up to that.
The police intends to continue with the investigation of the said proceeding. Stop. Paragraph. It will be open for the police to proceed with the investigation. Stop. Paragraph. The police will, however, not be entitled to arrest the accused persons without taking the leave of the court. Stop. The police shall keep in mind the ratio laid down by the Honorable Supreme Court in the matter of Haji Iqbal, no, not Haji, in the matter of Satyendra Kumar Antil, Mananda ekটু দেখে নেবেন, versus Central Bureau of Investigation and another, reported in 2022-10 SCC, page 51. Paragraph. Paragraph 2 of the judgment.
And so far the judgment relied upon by the respondent, lordship, kindly consider that.
Haji Iqbal?
No, by the state.
Niharika infrastructure.
Niharika.
Okay.
Niharika, that paragraph, lordship, kindly consider
Yes.
that.
Paragraph
I rely upon
33
that,
you
lordship.
said?
My lord, the
33?
paragraph 33.
Yes.
And the sub-paragraphs under paragraph 30.
Yes.
But they said that, and my humble submission, it does not come within the the exception carved out therein.
That is for quashing.
No, even the interim order also, it is stated therein, even the interim order, that no coercive step be taken, even and everything.
The court is not preventing you from taking any steps. Only prior to arrest, you take leave of the court. There is nothing else. I'm not stopping you from doing anything. You take steps.
Deeply appreciate.
My lord, the report filed, lordship, pursuant to my lord's earlier order.
Same order in item number 20 also. সেম এফআইআর।
কোনটা? without taking the leave of the court, ঠিক আছে। liberty to mention, এটা 21, item 20, the order passed in WPA 14941 of 2024 shall apply in the present case. এটা
My lord,
যদি বানানটা দেখতে লাগে আপনার।
my lord, would your lordship, my lord, desire that my lord state shall also file an affidavit with regard to that, my lord, the allegation contained therein?
Yes,
The report is something else, and my lord, the
Yes.
affidavit
No
is
problem.
something else.
The state respondents may file affidavit in opposition, within a period of
2 weeks or 3 weeks, my lord, kindly.
4 weeks.
4 weeks.
Reply if any within a fortnight thereafter.
ডিপলি অপোজ।
তারপরে লিবার্টি টু মেনশনটা দিয়ে দেবেন না হয়, দুটোতেই হবে, একটাতেই হচ্ছে আর অন্যটা সেম অর্ডার।
My lord, matter will appear, my lord.
I have given you the liberty to mention. Both parties will be entitled.
I think, my lord, it would be
To-
better, lordship, my lord,
What?
that so far our practical, my lord, experience is concerned, lordship.
Right now, with 3,000 matters in the list,
I know that, but
since there are benches taking up irrespective of years,
since, my lord,
irrespective
there
of
is
classification,
since
go
the
and
matter,
mention.
it carries an interim order. That is why I am telling before your lordship.
You
that-
come, we will see if it can be enlisted, we will enlist it.
Then, my lord, it may be perpetuity, lordship. Kindly consider one thing. Very difficult, my lord, to
Very
bring it in
difficult
the
for
list.
this bench also.
Any day, lordship, kindly, at least combine list.
Nothing. Call the next matter.